O'Brien to get to Ministry of Justice.
Yes, Mr. Allen.
Oh, my lady, I'm very anxious to finish in as close to 5 minutes as possible, so I should have some time to make an oral reply.
Yes.
So I put in front of you a note and drafted with my junior and obviously with Mr. O'Brien as well, those points which have not been fully covered or not covered at all. You will see that we've made some submissions in relation to direct effect under the second subheading, drawing on impact and bringing that up to date. Would it be permissible to simply ask the court to read those paragraphs?
Yes.
And we also then under the next heading, the recitals to the FTWD and the PTWD, Your Lordship, Lord Hope had asked us to consider recital 17 shortly.
It's in the same terms
I'm
as...
so sorry, I'm always doing this.
17 is the same terms as 16.
Exactly so. And we have just put some short notes down there in relation to that, which I'd like to take about a minute and a half to go through and to connect with a further submission. The passage I think that Your Lordship had in mind in recital 16 of the PTWD is in the last 3 lines in the first box at paragraph 7. Leaves the Member States free to define these terms in accordance with national law and practice, and then the qualifying clause, as is the case for other social policy directives using similar terms, providing that the said definitions respect the content of the framework agreement. And we submit that the effect of this text is that the respective directives cannot be construed and applied in such a way that a domestic categorisation of employment becomes the source of discrimination, which is of a kind that it is clear that directives were intended to prohibit. And we remind you of that passage in paragraph 29 in Del Cerro Alonso, which I cited yesterday. And we make a short note, in your Lordships will see in paragraph 29, the last bit, last sentence, as is clear not only from the third paragraph of Article 249, but also from the first paragraph of Article 2 of 9970, that's the FTWT, in the light of recital 17 of that directive, the Member States are required to guarantee the result imposed by community law.
Yes.
So we've put also before you Article 249, which will be very familiar to you. It's the directive-making power within the EC Treaty, the obligation on the Member State to guarantee the result.
And you've very kindly given us the equivalent in the TFEU.
Yes, and it just simply says underneath X249, so you can see where it is.
Yes.
So we've given you that.
The one point that arises out of the earlier part on direct effect, you haven't taken us to impact, have you? It's in the loose leaf.
We haven't. Essentially, that's an FTWD case, and except the same result is now achieved by Tyrols in relation to the PTWD. Right. Judgment in Tyrols was given on the 22nd of April, and that's the loose leaf folder tab E, and we deal with that in paragraph 2 of this note.
But that part of it's not in dispute, is it?
Well, it's not in dispute, but we say that it has an effect which goes further than that which the respondents would say, because once it's accepted that they have direct effect, it's implicit, we say, in both impact and Tyrols, that it is clear who are the beneficiaries of the two directives, which is, of course, the question in issue before this court.
Can you just expand for a moment on what you mean by that, please?
The two cases, impact and Tyrols, were concerned essentially with clause 4, the meaning of clause 4, the non-discrimination principle, which was said to have direct effect. But a directive can only have direct effect if it is sufficiently precise as to the nature and the extent of the right created. So that includes both the material scope of the directive and the personal scope of the directive. If only the material scope of the directive is clear, but it's not clear to whom or for whom rights are established, it can't have direct effect.
I want to just look very quickly at tab D in the bundle, because that's impact.
Yes, certainly.
Just to be quite sure, that the passage that caught my eye reading it last night was paragraphs 45 to 53, because it's describing the procedural autonomy of the member states and its limits, and it's brought to a point in paragraph 53, I think, which we can all read for ourselves. But I wondered whether I was addressing myself to the right part of impact in focusing on those paragraphs, and particularly what 53 is telling us, or whether there's something more to it.
I think 53, the comment in 53, in that context, it's for the referring court, which alone has direct knowledge of the procedural rules governing actions under domestic law, to ascertain whether the principles of equivalence and effectiveness have been complied with, is a slightly different point, isn't it? Because that is concerned with procedural questions which may, if not properly interpreted within the member state, operate as a bar to achieving the rights that are supposed to be conferred by the directive.
But it's the same idea, isn't it? It's for us, I suppose, looking back at Article 2.1 to see whether your case is brought within the formula in 2.1.
Yes.
But
the construction of 2.1 is the European law point,
yes.
Because the construction has to be conformable to the purposes of the directive as a whole.
Yes.
So we say, must bring your eyes to bear on clause 2.1, looking, to use that old analogy that's often used in submissions, through the lens of the purposes of the directive as a whole. Recital 16 says that the member state can construe the directive and apply it as it will, provided that it is in using terms in, as it were, no less an extensive way, as is the case for other social policy directives using similar terms. That's what it says in Recital 16.
Yes. The
So
last
that's
few words
minimum standard.
Yeah.
And effectively, we link that up with Percival Price, the analysis in Percival Price, tab 23 in Bundle 2, paragraphs 25 to 27, in which judges are treated as workers within the scope of Article, the Equal Treatment Article, what was 119, then became 141. We say that essentially, once it's determined that judges are workers for the purposes of another area of key social policy action, equal pay, that an interpretation of the Part-Time Workers Directive, which undermined that, is simply not possible. That's inconsistent with it is simply not possible. It's inconsistent with Recital 16.
If we got to the point, and picking up the last lines of paragraph 53 there, understanding it's not precisely in context, but if we got to the point of a reference, we see at page 97 of your written case, I think,
Yes.
what you're proposing.
Yes.
And I just want, I know I'm interrupting the progress of what you're saying, but we do need to be quite sure what we're to take from page 97. Would it help if you just took us through the terms of reference and explain why they're in these terms?
Yes, certainly. First of all, the point at 3 goes because that's the last point, but it now having been accepted that the provisions of clause 4.1 and 4.2 of the framework agreement are directly effective. That's having been accepted. That's not necessary to refer.
Yes.
The way we've tried to do it in 1, does Council Directive 9781 adopted to transpose Clause 4.1 of the Framework Agreement, which is the non-discrimination principle, in accordance with Article 2.1 of the Directive, to exclude part-time judges, the characteristics of whose working relationship with the respondent are set out in the schedule. And that phrase is very important because one needs to establish the nature of the characteristics of the relationship itself, just as was done in Cerro Alonso, where the contrast that the court had to address was between the classification of the Kingdom of Spain that had taken that those workers were regulated persons and not treated as employees, or not categorised as employees, whether that was sufficient to disapply Article 2.1. In our submission, therefore, the characteristics set out in the schedule, which we've then put behind that, which we think are non-contentious, essentially becomes the key background to the reference.
Yes.
The court here says there is a working relationship, fees are paid, but those fees are calculated by reference to the pay for circuit judges. I say circuit judges, I should have called them Crown Court judges. I'm sorry, that's the wrong title. It's the old-fashioned title. We've set out in the text that follows what we think is entirely non-contentious. One would obviously expand on that by reference to the documents as necessary, but we've tried to keep it fairly short. And then the question simply becomes one for the court to say, if you have found there is this kind of working relationship between recorders and the state, is it possible to conclude that that's outside the scope of the directive?
And question 2 really speaks for itself, I think,
Yes.
doesn't it? Yeah.
But isn't question 2 actually preempting the question of justification?
Let me reread it to myself before answering that question.
You might also consider whether the words "if so" at the beginning of question 2 are appropriate.
Yes. Well, you may consider that it's only question 1 that should be referred at this stage, if any question is to be referred at all. I would hope that you would consider possibly that it is not necessary to do that because of what we've already said yesterday. But if any question, then 1. But 2, as to 2, if so is a member state permitted in its implementing legislation to distinguish between part-time judges by reference to whether their remuneration is paid, it's a question which possibly could arise in due course, because as far as we can see at present, the only argument that's been adduced on justification is that you are fee paid rather than salary paid, and that's the justification that's been advanced. But I do take my lady's point that at one stage, simply haven't got to that stage in the argument.
That hasn't been what this case has so far been about.
This is absolutely correct, although, of course, one has anticipated that, and to some extent that has been the explanation that has been given. I suspect, I can't honestly say now that I can recollect exactly why we put that one in, but I suspect we probably feared that we could end up with 2 references, and we don't want to do that. But I do take my latest point that it is, in one sense, premature.
Right. Going back to question 1, I'm looking at the 5th line, and I just want to be sure that I follow the syntax of this correctly. Is the word "to" before "exclude" properly there, or does the sentence not read, does Council Directive and so on exclude part-time judges from?
No, does it permit a member state to exclude?
Permit a member state to include.
Oh, permit, I beg your pardon, yes, in the third line.
Permit a member state to exclude.
Yes, I see, the word permit, yes, thank you, yes, I followed it. Permit to exclude, yeah.
Yes.
Right.
There may be a more neutral way of phrasing the same question. just possibly.
Yes.
I have no doubt at all that it can be reformulated in different ways. In essence, though, what we think is critical is, and indeed as is required, as this court will know in the guidance given by the Luxembourg court, is that the factual context has got to be set, because you can't ask that question in a complete void.
Yes.
And that's why we've put the draft schedule in, to try and give some explanation for the context within which the question might be asked. I haven't said much about that. I don't suggest for a moment that it's perfectly worded, but we think it covers the key points that one would want to look at. I mean, for instance, in paragraph 4 on page 98, we've noted that the daily rate was equal to the circuit judges. Of course, it should be Crown Court judges' annual salary prorated to a daily figure. We would, I think, certainly wish to tell the Luxembourg court that it includes holiday pay, public holidays, statutory maternity pay, statutory sick pay, and so on. So those are other key factors which we haven't expressly set out there, but which could be put before the court as well. The other matters we think are really part of the context. It's interesting, we were looking last night at the notes given on the Court of Justice's website, and it says that they do expect you to set out a series of facts with a background for it. And it shouldn't exceed, I think, 10 pages is what is suggested. But we've obviously done it rather shorter than that. I don't know if the court's familiar with this, but it might be helpful to hand it up to the court, which it's the actual guidelines published in November last year by the Court of Justice on references.
Yes, well, thank you very much. We might find that helpful. Well, does that... I'm afraid I interrupted you and you're going through your paper, but...
Not at all.
Could I just ask you this? It probably shows my complete ignorance of the whole thing. Is the question whether there is an employment relationship on particular facts a matter wholly for community law in your submission?
The answer is that in our submission, this court has to, or the domestic jurisdiction has to establish the nature of the relationship in descriptive...
Well, that's why I include on particular facts.
Exactly so. In descriptive terms, it must do that. Because
well, let's assume it's done that. What's the answer to my question?
Once it's done that, then in our submission, that it is a question for the European Court. But I'll put it, if I can put it in this way, in the negative way, as to whether it is possible for the member state to exclude the application of the directive to such a relationship by relying on clause 2.1 of the agreement. In short, putting it another way around, whether whatever categorisation is given to it, it is no less than an employment relationship or a contract of employment. So does that a rather convoluted way of putting it, but I don't mean it to be. It is given that the obligation on the member state is to guarantee the rights in the directive. The European Court can say to the member state, you can call it what you like, but in order to guarantee the rights in the directive, then this set of facts must be considered to fall within clause 2.1. That is what it can say. It's the European Court isn't going to set up a new series of categorisations within the member state. It's only going to say that in order to guarantee the rights that are within the directive, that categorisation can't be used, as it were, to disapply clause 2.1, or on those set of facts it can do. And that's why we pointed out in the paragraph 7, 8 and 9 what the court was saying, that there were these minimum obligations, as it were, in transposing the directive. final point I want to say before I sit down is this. I haven't taken you through section Roman 4 of our case, starting at paragraph 2.17 and so on. The alternative way that we put the case is that if this court was of the firm view that there was no obligation to include judges within the scope of the PTWR, the regulations, nevertheless, it had included judges, but had then cut out a subclass of the fee-paid judges by Regulation 17. And the argument that we've set out in that section of our case is that it was not lawful to do so. At its simplest, as we have shown you in clause 2.2 of the agreement attached to the directive, the cutting out of a subclass is subject to a control mechanism which was simply never applied. So there's first a construction point. Whether or not judges had to be included, were they in fact included within the scope of the PTWR? And if so, then we say the conclusion must follow that Regulation 17 is unlawful, contrary to clause 2.2. That's putting it very shortly, but it's developed at length and in the case. And we conclude by saying it certainly was the view of Lords Nichols, Hope and Baroness Hale in Matthews, albeit that we weren't looking specifically at the scope of the PTWD in that directive, but it was certainly we had the PTWD in that case out in front of you, but we weren't looking at the scope point, we were looking at comparability. It was certainly your view that Regulation 17, properly read, presupposed that the regulations did apply to the generality of judges and sought to carve out a subclass. We think we've explained that fully in our case, and I'm not going to take any more time on it at the moment, because otherwise I shall have no reply time.
Yeah.
Thank you. Oh, sorry, 1 minute. I'm asked by Mr. O'Brien, before I sit down, to draw to your attention paragraphs 68 and 114. Yeah, 114 in impact, and that's in the judgment.
Well, that's tab 61, isn't it?
That's tab 61 of 3. Yeah. 68 is on page 2557.
Yeah.
In the middle of the page.
Yeah.
And the other paragraph is 114 on 2569.
Yes.
And 114.
Yes. So it's picking up
Picking
share
up
I
the
love,
cost.
so yes.
Yeah. One of those great benefits of having a silk as a client. But thank you.
Well, sometimes it is.
John, over to you.
Thank you very much, Ms. Councillor.
No, nothing further to add, thank you.
Thank you. Yes, Mr. Keltner.
My lords, my lady, we've taken the liberty of doing a note, a very short note of the introductory part of my submissions, which, if it's agreeable to you, I'll ask my learned junior to hand up.
Yes, of course.
Which serves, we hope, two purposes.
Yes.
One is that it's a short summary of the submissions that I will be making, but secondly, I hope it explains why I'll be making them in a slightly different order to the order in which they're set out in our case, and that is because I'll be dealing with the European law issues first, and then come on to deal with the domestic law issue, and in particular, the Percy judgment.
Yes. Now, there's a whole lot of things here. There's some cases we'll come on to
There are
later on.
3 cases which we notified to our learned friends on Friday that I'll come on to in a moment. But if I could invite the court simply to take the top document,
Yes.
Which is our opening summary. And at paragraph 2 of that summary, and I think this has been confirmed by Mr. Allen's answer to my Lord Clerk's question a few moments ago, his submissions are based on the proposition that European law requires that the definitions in Regulation 2.1 of the part-time workers regulations have to be interpreted in the broadest possible manner because that is what is required by European law. And he submits that European law requires that worker be given a comprehensive definition in the domestic legislation, the same definition as is used in the sex discrimination legislation in European law, and that must be grafted on or read into the domestic legislation, and therefore that any provision, and in particular Regulation 17, which is inconsistent with that broad definition, stands to be disapplied. So that's why in our submission one has to deal by looking at whether European law does indeed have that effect. And I begin with, I'm afraid, a very trite point, which is the language of the directive itself. On its face, Clause 2.1 says that it is for the law of the member state to decide who should come within the definition of part-time worker with an employment contract or employment relationship because of the words as defined by the law of the member state. And the importance of that is reinforced, we submit, by recital 16, of which, of course, the court is aware, which states that with regard to terms that are used but not defined in the framework agreement, the directive leaves member states free to define those terms in accordance with national law and practice, provided that the definitions respect the content of the framework agreement. And it is therefore our submissions, or will be our submissions, that the directive does what it says, that it is for the member state to define worker in this context, subject only to the need that the definition respects the content of the framework agreement. But since the framework agreement itself delegates, so to speak, to the member state the power to define worker, the very fact that worker has been defined by the member state in a way that may not be the same as in other EU legislation doesn't of itself make that domestic definition inconsistent or incompatible with the European legislation or the content of the framework agreement.
So you say that it enables a member state to carve out a particular class of people who do work and say that this whole set of protections shouldn't apply to them?
The straight answer is yes.
Yeah,
but I don't, I cavil perhaps at the word carve out, because of course carving out is the exercise conducted under clause 2.2, which is not on either side's submission the exercise that is being carried out.
Yes, but that would be the effect, that's the effect of your submission.
Yes, it is.
And where does that leave the principle of equivalence?
The principle of equivalence, of course, as referred to in impact, is a different principle. The principle of equivalence concerns time limits and procedural rules, and that is to ensure that the time limits and procedural rules that apply to European law rights are the same as those that apply to similar rights of a domestic nature in the domestic law's jurisdiction. There's a case in which I think Mr. Allen was in, certainly I was in, called Preston Wolverhampton Healthcare, which concerned time limits for pension claims in equal pay, which was an example of the application of the principle of equivalence, which meant that the court brought in the same time limits that applied in domestic law to the European law rights under equal pay.
But you're basically saying that it will be open to a member state, such as the United Kingdom, to provide that it would not, that, for example, cleaners would not qualify as workers for the purpose of Clause 2.1.
No, I don't need to go so far, my lady, for this reason, that judges are, we will submit, not and never have been regarded as people with an employment contract or an employment relationship in domestic law. And therefore, the definition under the regulations which excludes them is consistent with the position that has historically been the case in this jurisdiction. To exclude cleaners from that would not be the same. So I don't...
Well, that's the office point, isn't it? That comes down to the office point.
Yeah, it does. But my lady, I'm not trying to avoid the thrust of my lady's question, because we say that European law allows the member state a discretion. If it has a discretion, it must mean it can leave somebody out. If it can leave somebody out, whilst there may be questions at the margins as to which groups can legitimately be left out, if there's any group that can legitimately be left out, it must be the judges, because historically judges have not been regarded as having an employment contract or employment relationship in English law.
And why can't you leave out cleaners then?
Well, they have, of course, traditionally not been treated as a separate category, as a class of office holders.
Well, why has history got anything to do with it?
Well, it's the law rather than history, my lord. We say that the law in this jurisdiction has always been, and certainly was in 2000 when the regulations were implemented, being that judges are not workers, they're not employees.
But if it's just a question of law, then you could simply change the law to make it to exclude cleaners.
Yes, and that is my...
And if you did that, then on your analysis, that would be effective under the directive.
The issue that might arise there would be whether that respected the content. I appreciate, of course, this is the reason this question is asked, whether that would respect the content of the directive. But yes, in our submission, if a state were ill-advised enough so to do, then it might well be consistent with the power that is delegated to it by the directive. But in my submission, I don't need to go that far on this case, because this case is a less extreme example. What I will be seeking to do in due course is to distinguish the Del Quero-Alonso case, because that was a case in which the member state had tried to exclude the whole of the public sector from the scope of the directive. And that was held, and Del Quero-Alonso is the last in a line of cases to hold the same thing. That was held to go too far. And that, we would submit, is an example of a domestic piece of legislation which doesn't respect the content of the directive. But if I'm right on my premise that if there is a discretion at all, it must mean it's permissible to leave somebody out, then the next question I ask myself rhetorically is, if not judges, then who can be left out?
Well, I mean, judges aren't the only special class of office holders, and it is quite striking, and I'm sure you'll come on to it later. If you look at the regulations, Part 4, special classes of person, Crown employment in, armed forces in, House of Lords staff, House of Commons staff, police, all in. So all those office holders or people with a special historical position are in, and it's only the part-time judges when we find Regulation 17 tacked on the end.
Yes, my lord, there is one other category who's out, which is the territorial army, because in the provision that deals with those in the military, there's a specific exception for those who are not permanent members of the armed forces who are on training. But my lord, subject to that, that is right. But in our respect for submission, that shows, and I will come on to this, that as a matter of domestic law, all of those categories do not come within the standard definition of those with an employment relationship or an employment contract in domestic law. And the provision, we have copies of it because it's not in the bundle, the provision in domestic law through which the part-time workers regulations is implemented is not Section 2 of the European Communities Act, it's Section 19 of the Employment Relations Act 1999, which specifically gives the government a power to include additional groups beyond those that are within the scope that they are required to cover by the directive. So on the one hand, we would respectfully submit that the very fact that all these special classes are identified is a sign that in domestic law, judges and others, are not people who have an employment contract or an employment relationship. On the other hand, we respectfully submit that the fact that they are expressly included doesn't run counter to our argument that there was no duty to include them as a matter of EU law.
But just suppose that in Part 4, all the special classes had been excluded. Would that have emptied the directive of its content?
No.
It wouldn't.
In our submission,
What, even all the armed forces, all the police,
Yes.
all government servants?
Well, it's not all the government servants, my lord.
Well,
because-
sorry, Crown service.
Well, my lord, I will be coming on to submit, and indeed I think this is what my learned friend said yesterday, that the Crown employment exception is a belt and braces provision, because in the past there were doubts as to whether civil servants had contracts. Those doubts have been put to bed, in fact, in the authorities some years ago. But really all Clause 12 does is to make absolutely clear that there isn't an attempt to exclude the whole of the public civil service from the scope of the directive. Had there been, I would accept that that would have exceeded the discretion that the member state has, because that would then put the case on all fours with Del Quero Alonso.
But
Yep. Sorry.
I'm not clear what you say are the boundaries for the exercise of this discretion. Is it simply that so long as the content of the framework agreement is respected, then they can do anything they like?
Yes.
And what does that mean, respecting the content of the framework agreement in this context?
Well, that, in our submission, is where one derives guidance from the Advocate General in Whipple and Peake, because she says that there are very broad limits to the discretion granted to the member state. And I'm sorry to keep returning to the same point, but if there is a discretion to exclude, it must be possible to exclude somebody.
Are there principles to be applied, though? I mean, there must be some kind of criterion or test. Surely there's a principle which can guide one as to whether it's right to do it or not.
Yes, and in our submission, the principle, well, all one can derive from the authorities, because the European authorities deal with a very extreme case, is that it is not permissible to exclude the whole of the public sector.
That's not much of a principle.
Which, it's not much of a principle, but it was the only issue that's ever directly been considered by the European Court of Justice. The other point we submit that one can derive from the European Court, both in Whipple and in Del Quero Alonso, is that it is possible, at least if it's consistent, and I make that point conditionally, but at least if it's consistent with what has been the position in the domestic law, to exclude some categories from the scope of the implementing legislation without doing violence, without disrespecting, if I can put it that way, the content of the directive. So in my submission, there may be difficult cases, but this isn't one of them. It's my rather inelegant submission.
Yes?
And so if I may return to the first page of our short opening note, having made the trite point that on the face of it, the words of the directive grant a discretion to member states.
Well, we can't go by the words of the directive because of the proviso. Because if you just went by the words of the directive, then with one bound you'd be free. We know there's a proviso. The question is what the proviso means, isn't it?
My learned friend's submission, as I understood his answer to you this morning and also his answer to my Lord Sir John Dyson yesterday afternoon, is that actually there is no discretion at all given to the member state. The member state must include everybody conceivable within the meaning of worker, because to do otherwise would be inconsistent with superior principles of European law. So, forensically, in my submission, both my learned friend and I face in a way the same difficulty, but we have an answer and he doesn't. His difficulty is that on the face of his submissions, they are entirely incompatible with the language of the directive. Our submissions, we respectfully submit, are compatible with the language of the directive, although we recognise that there may be other cases in which it's difficult to apply the proviso that one must reflect the content of the agreement.
I'm not
You see,
sure.
I have-
Sorry. I was just going to say, I'm not sure that's quite fair to Mr. Allen. You see, he was concentrating on the word worker, whereas recital 16, to take for example, is talking about terms generally. And I think his point would be, well, when you get to the word worker, you're so much in the centre of what the content of the framework agreement is talking about that you really can't start excluding people. But there may be other terms, and we haven't gone to examine other terms, where it would be perfectly proper to do that. So, I mean, I think you have to be fair to Mr. Allen. He's got a very focused argument on the word worker, which is crucial, of course, to what we're talking about today.
Yes. My Lord, I certainly don't intend to be unfair to my learned friend, but Clause 2 does say it's for work...
Oh, yes, well, that was what I was going to say. There are actually two ways of reading Clause 2.1. There are probably 3, 4 or 5 or 6 ways of reading it, but
Yeah.
this agreement applies to part-time workers who have an employment contract or employment relationship as defined by the law, collective agreement or practice in force in each member state. Those words could be referring to whether or not it is an employment contract or an employment relationship, but not qualifying the basic point, which is part-time workers are covered. You see, it deals with both employment contract and employment relationship, clearly intending to include relationships which are not contracts. That's the whole point. And you could well read, as defined by the law, collective agreement or practice in force in each member state, as meaning that the difference between a contract and a relationship may be defined by the law, may be defined by collective agreement, may be defined by practice in each member state. Perfectly permissible way of reading that language.
Well, my lady, with great respect, of course, I don't...
You don't accept
that. To draw...
But I'm putting it to
that
you.
interpretation. But bearing in mind, I'm afraid there is a degree of repetition inevitably in my submissions, but bearing in mind recital 16, which taken in isolation, says that any words that are not given a specific definition in the directive are a matter for the member states free to define them. That would appear to encompass the word worker as well as the words employment contract and employment relationship.
Yes, I'm not going on the word worker. I accept there are different meanings in EU law to the word worker, and one question must be which is the right meaning in this. I'm simply getting at the construction of the subordinate clause in, yes, it is a clause, I believe, in clause 2.1.
Yes, well, my lady, I'm afraid I'm probably not going to be able to do more than suggest to the court, and I hope to try and bolster my submission by showing you some authorities, that the better interpretation of that provision is that the words as defined by the law, etc., relate to the whole of the phrase part-time workers who have an employment contract or employment relationship, rather than the second half of it.
Okay.
But that, of course, is my submission. May I just mention a point here that hasn't been mentioned so far in the submissions, that this is not the only directive which has a reference back to the law of member states, and there are others, which I will show you in due course, where the carving out, so to speak, has been much more substantial than is the case here. For example, in the parental leave regulations, a parental leave directive, it uses a similar formula, and in the parental leave regulations in this country, they apply to those who have contracts of employment. They do not apply to those who have contracts for services. So in the domestic implementing legislation of that provision, the apparent discretion given to the member state has been used to carve out a much wider excluded category than is the case here. And it may well be that that's because it doesn't do any violence to the principles behind the parental workers regulation, since the relationship of an employer and employee is a much more tight relationship, a much more substantial relationship than that of somebody with a contract for services with somebody else. But there's another example in the bundle, which is the Terms and Conditions Directive. Again, that directive has been applied in domestic law to cover only those with a contract of employment in the narrow common law sense. So the directive, the Part-Time Workers Directive, is not the only one that permits, we say, a member state to apply it to anything less than a comprehensive group of everybody it could possibly apply to. But, of course, our argument focuses upon the part-time workers' regulations themselves. And in that respect, and I'm now at the top of page 2 of my short handout, we noted down the answer that was given by Mr. Allen to a question from my Lord Sir John Dyson yesterday afternoon as to whether he was saying that there was, in effect, an autonomous meaning to be given to these words, or whether Clause 2.1 gave a discretion to member states within limits as to its application. And as we understood Mr. Allen's answer, he said that it gives an autonomous meaning. It has to be given an EU law meaning, which is the same as that which is applied under Article 119 to equal pay cases and under the sex discrimination directives to claims of sex discrimination. That is the type of meaning that was considered by the House of Lords in the Percy case. We, as you will not be surprised to hear, respectfully submit that he is wrong in relation to that, and that there is no uniform, autonomous and comprehensive meaning of the word worker that has to be applied to the part-time workers' regulations. And we say that the EU authorities provide support for our case because they make clear two related propositions. The first is that European law draws a clear distinction between words and phrases that have a uniform and autonomous meaning across the community, as is the case in equal pay and sex discrimination, and on the other hand, words and phrases in social policy directives like this one, whose meaning is specifically stated to be a matter for the law of the member state. And point 2 is, I'm afraid, the point I've already made perhaps too many times already, that if European legislation says, such as the Part-Time Workers Directive, says that the definition of worker is a matter for the law of the member state, then that will indeed be the position, subject only to the directive not being exercised in a way that makes a mockery or a nonsense of the directive. And I will, if I may, when I've come to the end of my summary of the authorities, or our submissions, take you to 2 or 3 authorities in which this point is made. But the first point, that the distinction, 2 different types of approaches to the meaning of words, has been referred to on a number of occasions in European Court of Justice judgments. The Chacon case was referred to by Mr. Justice Elias in the Christie judgment. And it will be our submission that Del Cerro Alonso is not a case, as Mr. Allen suggested, in which the clear guidance given by the Advocate General in Whipple was rejected by the court, and instead the court preferred a separate principle set out in the Jaeger case. Rather, in order to understand Del Cerro Alonso, one has to look at the 3 authorities that are referred to in it and which preceded it, Adenela, Vassallo and Morosu, all of which are cases in which it was argued that the whole of the public sector should be excluded from the scope of the directive. And this was traced back, and this is made clear, as I'll show you, in the Advocate General's opinion in Vassallo. This is traced back to an argument by the Italian government that since the social partners that reached the agreement, that formed the framework agreement in the Part-Time Workers Directive, were all from the private sector, the unions and the employers were only from the private sector, it must follow that the directive only applied to the private sector and not to the public sector. Not surprisingly, perhaps, the court and the Advocate General didn't accept that proposition. And we respectfully submit that what actually was happening in Del Cerro Alonso was that this was the last gasp, the last attempt on this occasion by the Spanish government to run the same argument that as a point of principle, the directive only applied to the private sector. And the court didn't, in Del Cerro Alonso, regard Jaeger on the one hand and Whipple on the other as being a line of inconsistent authorities, and then prefer Jaeger. Rather, we say there's nothing in the judgment in Del Cerro Alonso which cast doubt on Whipple. And what Jaeger is a case like Del Cerro Alonso itself, in which the law of the member state had attempted to do something which couldn't conceivably have respected the content of the directive. In that case, it was the idea that a doctor who's working nights in a hospital waiting to be called out on emergencies is not working while she or he does so. So in our respectful submission, Jaeger can be distinguished from the present case. And indeed, there's a further, slightly more nuanced point that I will seek to make in relation to Jaeger, which is that in Jaeger, the Advocate General in that case didn't regard the relevant provision of the directive as seeking to define working time at all. Rather, he regarded the form of words as simply a reference back to the arrangements in the member state for working time and time off and rest breaks and the like. So the Jaeger, we will say, can be distinguished also because that was a case in which the relevant provision wasn't seeking to delegate, so to speak, to the member state a power to make to define the words in a way that was different from the ways it may be defined in other states. So, in our respectful submission, the key, the clearest guidance that this court has is Whipple and Peake, predominantly, of course, I accept, the Advocate General in Whipple and Peake. The effect, now paragraph 11 of the note, the effect of Mr. Allen's submission is that member states, as we understand it, member states have no discretion at all as to how to define work. Indeed, he put it clearly in his case. There's a typo there, it's on page 37, not page 27 of his case. But he said there that mere classification in domestic law is neither here nor there. And we respectfully submit, as I hope I've indicated, that that submission cannot stand in the light of Clause 2.1, the recital, nor indeed Whipple, because EU law requires that it's the domestic law definition that is to be used, provided only that it respects the content of the directive.
So we have to ask you what that content is. This comes back to our earlier discussion. What is that minimum content?
Yes, and my lady, I
well, perhaps we'd better just stop now and ask the ECJ, really.
Yes. If I may say so, I anticipated that suggestion might be made. May I make it clear that our position in our case, and it remains our primary position, is that the point is act clear in our favour. If the court is against us on that, as every counsel in a European law case says, our secondary position is that we invite you to make a reference
well,
to
it's certainly commonplace for both sides to say it's the point is act clear in their favour.
Indeed so, my lord, and it's equally commonplace to do what I'm about to do, which is to say that it's certainly not act clear in my learned friend's favour. I should make clear that our position still remains, our primary position still does remain, that it is act clear in our own favour, and I will, if I may, show the court, the European authorities, that we say support that, and if they don't support that, at least support the secondary position, that it's certainly not so clear against us that you should do anything other than make a reference.
I beg your pardon, are you coming back to Whipple? Because just to be quite clear where you pick it up from the Advocate General, I think it's paragraphs 43 to 45, isn't it?
It is indeed, my lord. What I was intending to do, but of course I'm in the court's hands, this was just intended to be an overview, so to speak, of my submission.
Sorry, yes,
I will come back.
Yes.
I hope to take more or less in chronological sequence the European Court judgments and show you indeed 43 to 45 of Whipple.
Yes.
But returning to the question from my Lady Hale, how does one respect the content? It was put in our submission very aptly by Mr. Justice Elias in Christie that what one can at least say is that the member state has a reasonable leeway in defining worker. And one keeps, or at least I fear I keep returning, to the point that if there is a discretion at all, you have to be allowed to leave somebody out.
But
Because if not, there's no discretion.
Yes, but I suppose one of the principles one might think is that because the underlying principle in the directive is non-discrimination between full-time and part-time workers, if national law defines the full-timers as having an employment contract or relationship, then the equivalent people doing the same work part-time have to be included. That would be one principle, wouldn't it? In fact, it would be rather a good principle. I've just worked it out. And then you could ask yourself, well, how do we regard full-time judges or part-time salaried judges as opposed to part-time fee-paid judges? But you can see that there is logic and there is principle behind that approach. Simply saying we can take a group of people and say they're not covered is deeply unprincipled.
That's really why I picked up the principle of equivalence,
Exactly.
admittedly from a different context, but for the reasons Lady Hale gives, it has an attraction to it when you see what's going on in this country, the difference between the salaried and the fee paid, people doing exactly the same thing. And it does raise that question.
My Lord, in my submission there are two answers to the attractiveness of the point. The first is that by putting the question that way, if I may respectfully say so, it begs the question, because the principle of non-discrimination is a principle of non-discrimination between workers. If they are not workers, then the principle of non-discrimination has no application to them.
If you are correct that all judges are not workers,
Yes.
well then that leads to your case being consistent with the principle I've just put to you. But if in fact other judges are workers, just this lot aren't, that is inconsistent with the principle that I've just put to you. That's why I was putting it to you.
Yes. And my lady, of course, as the court is very well aware, our submission on the domestic law point is that judges aren't workers or don't have employment contracts or employment
In which
relationships.
case it was unnecessary to put Regulation 17 in at all.
Just as it was unnecessary strictly to put Regulation 12 in order to preserve the position in relation to civil servants. But my lady, yes, it is.
You have to go that far.
We do, indeed.
Yeah.
But in our respectful submission, it's not a question of defining part-time judges differently from defining full-time judges, because strictly, if we are right that the regulations exclude judges, then they exclude full-time and part-time judges, because the comparison is between full-time and part-time judges. It's not treating full-time and part-time judges differently. It's simply that the directive is there for the benefit of part-time judges, and so has a greater impact upon them. May I return to, it's now paragraph 13 of the...
So clause 17, or paragraph regulation 17, wouldn't be enough on its own from your point of view then, would it?
Oh yes, it would be enough on its own, because we say that properly construed, it is part of the process of defining worker. It's not carving out people who would otherwise be worker, it is part of the process of defining worker. And so for that reason, my Lord, we say that it would have been enough on its own. But as you will fully appreciate, of course, our principal submission, which was accepted by the Court of Appeal and indeed by Mr. Justice Elias, is that they don't have employment contracts, employment relationships, and they're not in Crown employment.
So if they were workers but for regulation 17...
They would not be workers. I'm sorry, I interrupted.
They would not be workers because of regulation 17?
Yes, that's our submission. Paragraph 13 really just sets out in writing what I've said far too many times already, which is that if the member state is entitled to define worker, has some discretion, it must be able to leave somebody out, or there would indeed be a uniform, autonomous and comprehensive meaning. And therefore, and I was told off by my junior for using disrespect in the wrong way, but I've used it anyway, that what it means is that leaving some people outside the category isn't contrary, doesn't disrespect the content of the directive, because the directive allows for a non-comprehensive coverage. And indeed, perhaps this is the point that I ought to have made a moment ago. In our respectful submission, the authorities show that some directives are more ambitious than others, in the sense that some seek to have a wholly comprehensive application to those who might possibly be affected by them in the member state. The sex and race equality directives are an example of that. Others do not. And framework agreements, social policy directives are the paradigm example where the ambitions of the Commission and the member states in giving effect to the directive are less than they are in other aspects of European law. And so in our submission it's not surprising that it is possible to exclude certain groups when you're applying the Part-Time Workers Directive, but it's not possible to exclude them when you apply the Equal Treatment Directive, which doesn't say anything about defining under the laws of the member states. May I move on briefly before I come to the European authorities to the just to give the court an overview of our submissions on the domestic law issue. And it starts from this proposition that if we're right that there is no overriding reason of European law why a broad meaning has to be given to worker employment contract or employment relationship in domestic law, then it follows that one doesn't need to strive to read Regulation 2 or Regulation 12 in a way that encompasses everybody, including judges. And one can contrast the position in relation to this directive and these regulations, therefore, with the Sex Discrimination Act and the Equal Treatment Directive. And may I just interrupt my introduction for a moment to ask the court to pick up the Percy judgment, which is in File 2, tab 24, to remind the court of the sentence in the judgment of my Lord Hope, paragraph 128.
The tab number again, sorry?
24, my Lord,
24.
224, 128.
Yeah.
This was in the section of my Lord's speech which dealt with the question whether the law specific to the Church of Scotland meant that Ms. Percy didn't have a claim under the domestic, a claim to bring a claim for sex discrimination. And my Lord said this at 128, the most significant feature of the Equal Treatment Directive for present purposes, however, is the absence of any indication that it was the intention to exclude from its protection any class or category of worker by reference to the occupation or profession on which they were engaged. Article 2.2 is then referred to, and I pick it up, Section 19 of the 1975 Act provides an example of a situation in the case of religious bodies where it was appropriate to exclude the application of the directive. For the rest, the wording of the directive indicates that the principle of equal treatment with regard to working conditions is of general application to all men and to all women. The court should not be astute to look for a qualification on this generality, which the directive itself does not provide for. If I may respectfully say so, we submit that's entirely right, and that's the right approach to the Equal Treatment Directive, but it's different with our directive, because our directive doesn't intend to be a general application in quite the same way. As regards, I'm just returning to the last few paragraphs of my note, as regards the meaning of worker, we do rely on the authorities up to and including Percival Price, which we say provides support for the proposition that as a matter of domestic law, judges do not have contracts of employment. We don't dispute for a second that many office holders do, but we say that some office holders don't. Not only judges, police officers is the most obvious example of another office holder who doesn't and shouldn't be regarded as having a contract of employment. And we rely also on the authorities collected in our case that support the proposition that judges are not in Crown employment either, because they don't work under or for the purposes of a government department, etc. And I dealt with this in response to a question from my Lord Clerk. Judges, we say, would have been covered even without Regulation 17, but Regulation 17 puts it beyond doubt as a matter of belt and braces.
But not on the footing that they're not workers. I mean, Regulation 17 simply excludes them.
Yes, but...
And you only need Section 17 if they are workers.
Yes, but we say it's belt and braces because there was some question mark and references made to Percival Price, both by my learned friend and by the Court of Appeal, as to whether they might have been considered to be workers. But we respectfully submit that what this is not about is any attempt to suggest that office holders cannot have contracts. Many office holders do. It's not an attempt to suggest that there is no intention to create legal relations where judges are concerned, because they do have a legal status. They have a statutory office. What we do respectfully submit is that they don't also have a contract of employment with the Minister of Justice or the Lord Chancellor or whoever else it might be suggested they have a contract with. And indeed, we submit that if Mr. Allen was right, then it would be hard to see that there would be any office holder who would not also have a contract. Because, and this brings me to paragraph 22, and perhaps the last point I'll make before taking you to the authorities. Much of my learned friend's submissions yesterday were directed to the proposition that the terms and conditions, manner of appointment and so forth of judges is similar to that which you would see in a contract of employment. And in the broadest sense, that, of course, is right. But we respectfully submit that's not enough, because the actual definition set out in the part-time workers regulations is for there to be a contract, either employment or a contract for services. There is no separate subsection saying or a employment relationship within the part-time workers regulations. So it doesn't, therefore, we submit, apply to somebody who has a relationship which in some ways resembles a contract, but is not a contract. On the point of reference, I've already made my rather two-faced submission clear, I hope, in an answer to my Lord Clerk. I don't mean that flippantly, but we do submit that it's Act Clare. If it's not Act Clare, then we respectfully invite you to make a reference rather than find that it's Act Clare in favour of my learned friends. May I then start the main body of the submissions by taking the court to some new authorities, in the sense that they're not authorities that were mentioned in our case nor in my learned friend's case, though one of them, the first one, was mentioned by Mr. Justice Elias, as he then was, in the Christie case. And the proposition I seek to derive from these authorities is as follows: that a different approach should be taken to the interpretation of words or phrases when the directive makes an express reference to the law of the member state for the purpose of deriving its meaning and scope on the one hand, and cases where the directive doesn't make any reference to the law of the member state on the other. And the first of the authorities, and I hope it's the first in the pile that you have, is Chacon Navas and Urest, which is a judgment of the Court of Justice in July 2006. This concerned, as one can see from the headnote, the meaning of the word disability in the disability or the Equality Directive 2078, and the particular issue was whether it was necessary for the member state to provide that disability meant any form of sickness. That proposition was rejected by the Court of Justice. But in our respectful submission, it's clear from the passage I'm about to show you that the court held that there was an autonomous and uniform meaning across Europe to the word disability, precisely because there was no express reference to the law of the member state. And it's paragraph 39 and 40 of the court's judgment, page 21 of the photocopy, to which I'd like to draw attention. The concept of disability is not defined by the directive, nor does the directive refer to the laws of the member states for the definition of that concept. It follows from the need for uniform application of community law and the principle of equality that the terms of a provision of community law which makes no express reference to the law of the member states for the purposes of determining its meaning and scope must normally be given an autonomous and uniform interpretation throughout the community, having regard to the context of the provision and the objective pursued by the legislation in question. And then at 42, in the light of the objective of the directive, the concept of disability must, in accordance with the rules set out, be given an autonomous and uniform interpretation. So this is one of the class of concepts or words where there is no express reference to the law of the member state, and for that reason, the court says, must be given an autonomous and uniform interpretation throughout the community. And just for the court's notes, at paragraph 64 of the Advocate General's opinion, at page 12, he collects a list of authorities that all say the same thing in the usual manner of Advocate Generals and the court, where concepts such as this should be interpreted autonomously and uniformly. May I try the court's patience by taking you just to two others? One, partly because its facts are so unusual, but also because of some slightly more clearer guidance one can gain from it. And that's the case of Adolf Trulli and Bestattung Wien. This was a case, a public procurement case, about the supply of coffin fixings to an organisation which gloried in the name of Funerals Vienna. It was a public body charged with organising funerals in the Vienna area. And there was a dispute about the procurement of coffin fixings. And just, again, perhaps to save time for the court's note, the nature of the dispute is set out in paragraphs 2, 3, 7 and 13 of the court's judgment. But on paragraph 2 of the judgment, under the heading Legal Framework, it says that Article 1b of the relevant directive says, for the purposes of this directive, a body governed by public law means any body established for the specific purpose of meeting needs in the general interest, not having an industrial or commercial character. The issue in the case was whether Bestattung Wien was a body governed by public law, and in particular, whether by conducting funerals it met needs in the general interest. And one of the issues that the court considered was whether this was to be defined by European law or by reference to the national legal system. One sees that at paragraphs 27 and 28 of the judgment, which I won't read out because they say, I hope, exactly what I've just observed. The National Court asks whether the term is to be defined by community law or by the national legal system of each member state. And the court's reply begins at paragraph 33. First of all, it should be noted that the directive does not define the term needs in the general interest. And then at 35, according to settled case law, the need for uniform application of community law and the principle of equality require that the terms of a provision of community law, which makes no express reference to the law of the member states for the purpose of determining its meaning and scope, must normally be given an autonomous and uniform interpretation throughout the community. And that interpretation must take into account the context of the provision and the purpose of the legislation in question. In the present case, it's common ground that the relevant provision makes no express reference to the law of the member states, with the result that the aforementioned terms must be given an autonomous and uniform interpretation throughout the community. Again, therefore, the very first question that the court asked itself was whether there was express reference to the law of the member state, and the clear implication, we respectfully submit, was that if there was, then the starting point would indeed be the law of the member state. The third of the authorities is a case that was a reference from the United Kingdom, a case called Yayadon, which I cite also only for this reason, that this was a case that concerned a fundamental right, and yet again reference is made to the question whether the law of the member state provided for whether it was for the law of the member state under the directive to provide the definition. If I can just summarise what the facts of the case were, it concerned Directive 64221, which is about movement and residence of foreign nationals. What had happened in this case was that Ms. Yayadon had been temporarily admitted into the United Kingdom, and then 7 months later, a decision was taken refusing her entry. She had a right of appeal, but if it was a decision concerning entry under the terms of Article 8 of the directive, the UK could require her to go abroad in order to bring her appeal, whereas if it was a decision refusing the issue of a resident permit or an expulsion, then she had a right to remain because Article 9 would apply. So the issue which is relevant for present purposes is the meaning of the words a decision concerning entry in Article 8 of the directive. And at paragraph 24 of the court's judgment, I'll take the judgment first and then return to the Advocate General's opinion.
So we're page 6 of 8, are we?
Yeah, my lord, I have it in a different version.
5 of 8, sorry.
5 of 8,
Five
yes,
of
I'm
eight,
sorry,
yes.
I do have it in the same version.
Yes.
Paragraph 24, the court has consistently held that the principle of freedom of movement of persons must be given a broad interpretation, whereas derogations from that principle must be interpreted strictly. In the same way, provisions protecting community nationals who exercise that fundamental freedom must be interpreted in their favour. It should also be recalled that the need for uniform application of community law and the principle of equality required that the terms of a provision of community law which makes no express reference to the law of the member states for the purpose of determining its meaning and scope must normally be given an autonomous and uniform interpretation throughout the community. And then the same form of words is used as we've seen in the other judgments. Paragraph 28, Article 8 of the directive requires member states to provide for member state nationals the same legal remedies in respect of a decision concerning entry or refusing the issue or renewal of a residence permit or ordering expulsion from the territory as are available to nationals of the state concerned in respect of the acts of the administration. And it then goes on to consider which applies, and the answer was that she should be treated as having been granted entry, and therefore it was a decision to expel her, and she was allowed to stay in this country whilst it was considered. But the reason that I've relied upon this also is that this is a case which concerned fundamental rights and principles that need to have a broad interpretation, yet the court also referred to the fact that the directive made no express reference to the law of the member states. And so in our submission it reinforces the proposition that if it had done, then a different approach to interpretation would have been appropriate. And the Advocate General's opinion on page 6 of 12 paragraphs 42 to 45, says this. Let us be clear at the outset that that notion, that's the meaning of the words concerning entry, cannot depend on the classifications applied by national laws. It is clear from the settled case law of the court that the community legal order does not aim in principle to define its concepts on the basis of one or more national legal systems without express provision to that effect. That principle applies not only to the provisions of the treaty and to regulations, but also to directives. The interpretation of a term used in the provision of a directive, which does not refer to the law of the member states for the determining of its meaning and scope, cannot be left to the discretion of the member state. This directive makes to the law of the member states no reference which would argue in favour of different interpretations according to national law. And then it goes on. So again, the strong implication we respectfully submit is that the Advocate General is saying that if there had been a reference to the law of the member state, then that would argue in favour of different interpretations according to national law. May I now come to...
Is there a decision of the court which makes that point in a case where there is reference to the national law?
No, not that we've been able to find. The only one is Whipple, but of course, as we will see, and I fully accept, that point is considered much more directly by the Advocate General than it is by the court. But may I ask the court to turn to Whipple and Peake now? And I think you have it in the loose leaf volume rather than in the main authorities bundle. It's at tab G. My learned friend has already introduced the facts to the court. It concerned what is ordinarily referred to as a 0 hours contract. So may I go straight to the relevant passage in the Advocate General's opinion, beginning at page 1616 in the law report, paragraph 42. But sorry, before I do so, I should remind us all that the claim by Miss Whipple was not brought solely in relation to the part-time work directive, but also in relation to the equal treatment directive. And it's my respectful submission that it's instructive to see the different approach that's adopted by the court and by the Advocate General in considering the meaning of worker in those two different directives. And paragraph 42, they begin, or she begins, I should say, with the meaning for the purposes of the, what is in fact the Equal Pay Directive and Article 141, as was now Article 119, the Equal Pay Article. And also the Community Charter on Fundamental Social Rights. Paragraph 43, she says that there is no single definition of worker in community law. The meaning of the term depends on the particular provision concerned, and a direct distinction, she says, should therefore be drawn in this respect between the framework agreement on part-time work on the one hand and Article 141, the Equal Pay and Equal Treatment Directives and the Community Charter on the other. And it's that distinction upon which we respectfully rely. She then goes on to deal with the concept of worker under the part-time work agreement, the directive, sets out clause 2.1 and says this: consequently, for the purposes of the framework agreement, the term worker is not a community law concept. Indeed, the personal scope of application of the framework agreement is defined by reference to the national law applicable in each case. The term worker therefore has to be defined in reliance on the law, collective agreements and practices in force in each member state. The member states have wide discretionary powers in this respect. Only the very broadest limits can be determined in this respect by reference to community law. It could therefore constitute a breach of the duty of cooperation if a member state were to define the term worker so narrowly under its national law that the framework agreement were deprived of any validity in practice and achievement of its purpose were greatly obstructed. However, there is no sign of that here. Now, pausing there, that's the best we have in my submission as a response to the question that I've been asked by members of the court as to where is the line drawn in relation to respecting the content of the directive. It may not be a very bright line, so to speak, but it is the only guidance that we have emanating from the Advocate General or the court. And although, as I've said, one recognises that there may be difficult marginal cases, this, we say, is not a difficult marginal case. And that one thing that is overwhelmingly clear from this passage is that she acknowledges that it is possible for the state to leave some people out, because otherwise there wouldn't be a discretion at all. In fact, as was said in the Vippel and Peak, the domestic legislation, the Austrian legislation, had a very broad definition of worker, which included 0 hours contract, and so the Advocate General said that that was to be respected. She then goes on, and I don't need to read it unless I'm asked to do so, but paragraph 47 and following, she then goes on to conduct a different analysis where the equal pay and sex discrimination legislation is concerned. And perhaps just paragraph 47. Article 141, etc., do not contain any express definition of the term worker. It is therefore necessary, in order to determine its meaning, to apply generally recognised principles of interpretation, having regard to the context in which the term is used and the objectives of the treaty. So it's a different approach in our respectful submission in such a case. The judgment of the court deals much more briefly with the relevant issues, but may I pick it up at page 1640, paragraph 29. The question the court is asking itself is whether a contract of employment, such as in the present case, comes within the Equal Treatment Directive, or whether it comes within Article 141 and Directive 75, that's the Equal Pay Directive. And paragraph 30, it says in brief that the answer is yes. It must be held that such a contract lays down rules concerning working conditions within the meaning of the Equal Treatment Directive, and they come within the scope of employment conditions. Then it moves on at paragraph 35 to ask, perhaps I've not properly described it because it's here that it now comes on. It was really the passage I was just looking at as to whether they were employment conditions that were an issue in the case. So paragraph 35 and onwards, that it comes to look whether the type of contract comes within the Equal Treatment Directive or the Part-Time Workers Directive. As regards the Equal Treatment Directive, it's the work of a moment to say that it does. That's dealt with at 36. However, as regards the Part-Time Workers Directive, what it doesn't say is that the same principles apply. Whereas if my learned friend's submission was right, that's all the court would have needed to say. Rather, it goes, perhaps, if I may respectfully say so, not terribly helpfully, simply to recite the provisions of the directive itself. It sets out clause 2.1, clause 2.2, and 39, it says that it's for the referring court to make such determinations as may be necessary in order to verify whether the conditions in 2.1 and 2.2 are met. And I mention that in parentheses. I'll return to it when I come to make submissions in relation to the form of a reference, if one is to be made.
Does 39 refer back to 37 as well as 38?
Melody, I think it does. I must say, the first time I read it, I thought it was only 38.
Yes.
But just this time I thought it might refer to both.
It's not clear, is it?
It isn't clear.
It clearly refers to 38.
Yes.
It's not clear whether it refers to 37.
Yes. And it would make perfect sense if it only referred to 38.
Yeah.
But of course, the key, insofar as there is a key provision or paragraph in the judgment, for our purposes, is 40. Because what the court says is this: in the light of the foregoing considerations, I should say the first part of the paragraph returns to the Equal Treatment Directive. In the light of the foregoing considerations, the reply to the first question must be that a worker with a contract of employment, such as that in the main proceedings, under which hours of work and the organisation of working time are dependent on the quantity of available work and are determined only on a case-by-case basis by agreement between the parties, comes within the scope of the Equal Treatment Directive. Then it goes on, such workers also come within the scope of the framework agreement annexed to the directive. Keyword is where, and then the conditions set out in clause 2.1 or clause 2.2 and clause 2.2 are set out. So the court says it is necessary, because in my submission that's the import of the word where, it is necessary that they have a contract or employment relationship as defined by the law, collective agreements or practices in force in the member state. What is not suggested is that that's really a dead letter, because in fact it's a European law principle which overrides any apparent discretion that the member state should have. So in a way, in our submission, the significance of Whipple and Peake is what it doesn't say. It doesn't say what it ought to say if my learned friend's submissions are right about it.
I must say, looking back at 39, it does seem to refer to what 38 is talking about.
My lord, I think that's right. Yes, I don't seek to persuade the court otherwise.
Could I ask you, I'm not sure how far it's essential to your argument, but you've made, you say there's an important distinction between what you call directives concerned with social policy and directives concerned with combating discrimination. I find that quite hard to see that is a clear distinction. And after all, if you look at the framework agreement we're concerned with, Clause 1, the purpose of this framework agreement is to provide for the removal of discrimination against part-time workers. And if you look back to the Advocate General Cockett, page 1617, 49, paragraph 49, she's referring to the Equal Pay Directive and the Equal Treatment Directive as concerned with social protection. I mean, at most, they're just nuances, aren't they, of the same sort of thing?
They are. We'll see, and if I may, I'll show the court this when I get to Del Cerro Alonso, but in the Advocate General in Del Cerro Alonso does draw a distinction between various types of directives, despite the fact that each of the directives really is concerned with fundamental rights, so that it takes account of differences between what I've called the discrimination directives, which are directives that deal with personal characteristics, like race, sex, disability and so on, as opposed to things that deal with working circumstances.
Sure, but we know that part-time workers are predominantly women across the whole of Europe, and that's why it is also indirect sex discrimination. So again, I don't find it a very clear-cut distinction, really.
Yes.
But you'll come on to that.
I'll come on to it if I may. Of course, in the particular circumstances of part-time judges, there is no disparate impact between men and women in terms of the cohort of part-time as opposed to the cohort.
Yeah, but I'm just trying to understand
judges.
the general submission you're making about how we should approach these things.
Yes.
But with respect, has anybody done that piece of work? Bearing in mind we're talking about a very large number of part-time judicial officers, not only recorders, but also, of course, all the part-time tribunal judges and equivalent officers. And I thought I'd seen in the submission from the Council of Immigration Judges something that indicated that there was a disparate impact.
That, my lady, was disparate impact within the cohort of immigration judges, whereas the figures that you'll find, I think it's paragraph 104 of our case, but there are figures in our case which deal with the totality of part-time judges, of whom there are some 8,500
Yes.
full-time and 8,500
I'm absolutely amazed that you can actually get the information.
Well, it wasn't easy, and it took, I allocated the task to those instructing me and took some time, but
We do have the figures from the LCD website on judges.
But in any event, my lady, all I can say is those are my instructions. And those were not instructions taken off the back of an envelope. They were the results of some work that was done.
But you haven't done the kind of exercise that we get in the written submissions for the immigration judges in paragraph 16, which puts a percentage figure, a comparison figure between, I think, men and women.
Yes,
Disadvantage.
my lord, I stress that as I understand it, that's within immigration judges rather than across the board for the whole of the judiciary.
Yes.
And our understanding is that's not representative.
Yeah, just coming back to what the court is saying in Whipple, I must say, speaking for myself, I really don't think one gets very much out of paragraph 40 at all. I mean, it's perfectly true that they refer to the relationship as defined by the law, the national law of the member state, but they don't begin to grapple with the difficulties of the boundaries and the reservation in the recital. Does one really get anything very much from this at all?
Well, my lord, that, with respect, I agree, and that's why we submit that what one gets from it is what it doesn't say, because it doesn't stop, as it should have done if my learned friend is right, in saying that exactly the same categorisation of worker must be used for the purposes of a directive such as this as is used in the sex and race discrimination directives. But it doesn't seek to blur the impact of clause 2.1. It doesn't seek to avoid the express delegation, so to speak, to the law of the member state. But that I don't seek to make my case too high in relation to the court in Whipple, because it doesn't say things in words of one syllable as one might have liked to see. May I invite the court to go next to the Jaeger case, which is in the bundle, tab section 4, or file 4, tab 64.
This is Kiel.
Kiel, I'm sorry.
Yes, it doesn't matter, it's the same.
I've been involved in other cases involving it in which we called it Jaeger, so I apologise. This is the case about the doctors on night duty. And the submission that I seek to make in relation to it is to distinguish it, really, to say that it's different. That the issue concerning Article 2 of the Working Time Directive, which is what refers to working time, and which is what was considered in Jaeger, was different from the issue with which we're presently concerned in three respects, three cumulative respects. And I'll just set out what they are and then make my submissions on them, if I may. The first one is that as the Advocate General in Jaeger interpreted Clause 2.1 of the Working Time Directive, it wasn't intended to be a definition provision at all. It wasn't intended to say anything about definition. Secondly, the domestic law that was being considered in Jaeger was the paradigm case of domestic law which did not respect the content of the directive. To use the cliche, it drove a coach and horses through it. And third, and this to a small extent touches on the question that was asked me by my Lord Walker, this is a different type of directive. It's a health and safety directive rather than a social policy directive. And that's a point that's made by the Advocate General in Del Cerro Alonso. As regards the interpretation point, the question whether Clause 2.1, or Article 2.1, I should say, of the Working Time Directive covered was intended to be a definition. The relevant part of the Advocate General's opinion is paragraph 36, but may I begin at paragraph 35?
Page number?
1539.
Yes. Okay.
The last sentence, Directive 93/104 is the Working Time Directive. Last sentence of 35, the Advocate General says that the Working Time Directive does not envisage an intermediate category between working time and rest periods, and then says this: thirdly, despite the fact that Article 2 of the Working Time Directive provides that the three criteria used to define working time are to be specifically delimited in accordance with national laws and practice, that stipulation does not mean that member states may refrain from applying those criteria and rely on rules of national law. In order to calculate an employee's working time, it's necessary to ascertain whether, under national law or a collective agreement, that employee is entitled to take a break every certain number of hours. However, a member state may not rely on its own legislation to support a view that a doctor who carries out periods of duty on call in a hospital is not at the employer's disposal at times when he is inactive, but is waiting for his services to be called on again. And I should have shown you, and haven't done, the relevant article, which is on page 1533. For the purposes of this directive, the following definition shall apply. Working time shall mean any period during which the worker is working at the employer's disposal and carrying out his activity and duties in accordance with national laws and or practice. Now, perhaps picking up on a point that was put by way of a question to me by my Lady Hale some time ago, the reference to in accordance with national laws and practice is ambiguous in that provision. It could either be national laws and practice defining the words in quotations working time, or it could simply be a much less significant use of the words simply to mean that it's the period that they do working in accordance with national laws and practice about when you work and when you don't work. And it's the latter meaning that was afforded to it in this directive by the Advocate General, though it's fair to say, I think, that that is not expressly adopted by the Court of Justice. But so one potential point of distinction between the Jaeger case and the present case is that the clause in the directive in Jaeger may have had a different intention, not trying to define at all the words in contrast to the fixed-term workers directives. And in that context, and may I do this by giving you the citation unless you wish me to show you it, the Working Time Directive itself is in file 6, tab 118, and it doesn't have a recital like recital 16. I won't show you it just to show it doesn't, but at least we haven't been able to find one. So
tab 6, bundle 6, tab
118.
118, sorry, thank you.
So that may also reinforce the possibility that there is a different purpose behind the wording in the Working Time Directive as opposed to the Part-Time Workers Directive. The second point of distinction we rely upon is that the domestic legislation in Jaeger was wholly incompatible, in the court's view, with the meaning and purpose of the working time regulations. And one can see the reasons why from the Advocate General's opinion, though it's also referred to in the court's judgment. What was being said in German law was that a doctor who's hanging around a hospital, awake or asleep, waiting to be called for emergencies, is only working when they're actually doing the emergencies, and the rest of the time they're not involved in working time. Paragraph 27 of the Advocate General's opinion, page 1536, the Advocate General says that the fact that the employee is able to sleep doesn't mean that those periods should be excluded from the notion of working time. And then further on at page 1539, paragraphs 35 to 38, the Advocate General makes clear his view that what was going on in Germany couldn't possibly be compatible with the directive. He says at 35 that although the intensity and extent of activities carried out while on call are not the same as during working hours, it does not mean that time spent on call becomes rest time for the employee. And as I already read out, the Working Time Directive doesn't envisage an intermediate period. And at 37, the fact the doctor is able to sleep while his services are not required stems from the very nature of time spent on call. The service which responds to the need for medical care to be available at all times, although the conditions in which it's provided differ from Monday to Friday, but nevertheless, doctors on call do not merely act punctually when required to do so, since their duties also include monitoring on their own initiative the condition and progress of patients. How would one regard an employer who, instead of providing the doctors with a bed, provided only a chair for the doctor to sit on whilst he waited to be called to duty? I wonder if the referring court would feel that the time spent by the doctor sitting on a chair is closer to the concept of working time than time he spends lying down on the bed. So it's absolutely clear in the Advocate General's view that it's simply impossible to reconcile the German law with the spirit and intendment of the directive. And as for the court, the relevant passages, paragraphs 58 and 59 of the judgment, page 1555.
I think actually, just to get the context of them, you need to look at 44 and 45, because that's really picking up the point you just made, I think.
My Lord, yes.
That you look at the social purpose, the purpose of the directive and so on, which they identified there, and then you come on to 58 and so on.
Yes. Yes, indeed so. So as my Lord points out, it's minimum requirements to improve the living and working conditions of workers.
Yes.
Through approximation of national law. And then at 58, the court says, in any event, the concepts of working time and rest period within the meaning of the Working Time Directive may not be interpreted in accordance with the requirements of the various legislations of the member states, but constitute concepts of community law which must be defined in accordance with objective characteristics by reference to the scheme and purpose of that directive. Only such an autonomous interpretation is capable of securing for that directive full efficacy and uniform application of the concepts in all the member states. Accordingly, the fact that the definition of the concept refers to national laws and practice does not mean that the member states may unilaterally determine the scope of that concept. Thus, the states may not make subject to any conditions the right of employees to have working periods and corresponding rest periods duly taken into account. Now, pausing there, that sentence in my submission goes on to a different point, because what it's saying is that you can't undermine the rest periods by imposing conditions and qualifying for them. And then it says any other interpretation would frustrate the objective of the Working Time Directive of harmonising the protection of the safety and health of workers by means of the minimum requirements. And then they dealt with the opt-out judgment in the United Kingdom and Council case in 1997. The third point of distinction is one that, if I may, I'll ask the court to turn to Del Cerro Alonso briefly. I'm going to come back to it, of course, in significantly more detail. But Del Cerro Alonso is at volume 3, tab 51. In the Advocate General's opinion in Del Cerro Alonso, paragraph 13, and I stress I'm going to come back, I'm afraid, in much more detail to go through the judgment in this case, but can I make a guerrilla raid on paragraph 13, which is on page 150 of the judgment.
Yeah.
Let's start paragraph 12.
Yes.
It's true that the fixed-term directive expressly makes reference to national law. However, it seems that the case law does not consider such a process to be decisive for the purposes of interpretation. The court has held, in the context of the Working Time Directive, that the concept of working time constitutes an independent concept of community law, which must be defined in accordance with objective characteristics, notwithstanding the fact that it's the subject in that directive of an express reference to national law, see Jaeger. Conversely, the court has held in an area closely related to that, an issue in this case, governed by the Framework Agreement on Part-Time Work, that workers come within the scope of that agreement where they have a contract or employment relationship as defined by the law, etc. See Whipple and Peake. Now, pausing there, he then goes on in my submission not to say that those are inconsistent with each other, but that there's an explanation for the difference, because he goes on to say that difference in the treatment of references in social matters arises from the way in which the matter is approached, depending on whether the Court of Justice attaches more importance to the purpose or to the scheme of the rules subject to interpretation. As far as the organisation of working time is concerned, the Court of Justice points out that the directive in question pursues a fundamental social objective, which is to guarantee better protection of the safety and health of workers. Consequently, although that directive is limited to laying down minimum requirements for that purpose, only an autonomous interpretation of the concept of working time, guaranteeing uniform application, is capable of securing for that directive full efficacy. On the other hand, both in regards to transfers of undertakings and in regard to part-time work, the court, contrary to the opinion of Advocate General Albert, essentially accepts that the directive in question is not intended to establish a uniform level of protection in the community or allows the member states a certain discretion. In those circumstances, it must be acknowledged that the concept of worker is defined exclusively by reference to the applicable national law. Now, he then goes on to propose what he describes as a slightly different approach. If I may, I'll come to that when I come to deal directly with Del Cerro Alonso. But in the meantime, in my submission, he is not regarding Jaeger on the one hand and Whipple on the other as an inconsistent line of authority that needs to be determined one way or the other by the court in Del Cerro Alonso. Rather, he regards them as wholly consistent with each other. And the explanation for the apparent difference in approach is because of the extent to which the rights that the directive covers are regarded as fundamental as a matter of European law. And
it's the uniform level of protection, isn't it?
I beg your pardon, my lady.
It's the uniform level of protection which he's focusing on, which goes back to what we were discussing earlier, that it may very well be that the purpose of the directive is to make sure that in a particular country, part-time workers are not treated less favourably than full-time workers are treated in that country. But they're not necessarily trying to achieve the same treatment for all people who are doing work throughout the community.
My lady, yes. But it does mean in our respectful submission that if this Advocate General has correctly described the law, that it is possible for member states to apply the part-time workers legislation to less than a comprehensive body of people. And if perhaps I'm reading too much into the import of my lady's question, but in my submission it follows from that it's not necessary within the country that everybody who could possibly be considered a worker in the most general sense must be captured by the scope of the implementing legislation, because there is a right to have a bespoke national coverage of the legislation. And I think that this may shed some light, or at least I hope it does, on my answer to my Lord Walker's question in relation to the... my Lord's question was about equalities and how the sex discrimination directive and so forth was in many ways very similar to the part-time workers directives because all use the language of discrimination.
It may shed some light. I just still don't find it crystal clear. Of course, Mr. Allen has an alternative and simpler explanation of why there's no inconsistency between Jaeger and Whipple. He says that Jaeger shows that you can't rely on national law to cut down the protection. Whipple shows you can rely on Austrian law to increase the protection.
Yes,
and that is a very simple explanation, if it's right.
It doesn't, unfortunately, have the merit of having any reference made to it, of course, in either the court's judgment in Whipple or in any of the cases that follow on from it. And it's not, of course, the explanation that's set out by the Advocate General in this passage in Del Cerro Alonso, in my respectful submission.
I thought he drew something from paragraphs 14 and 15, didn't he? The slightly different approach.
Yes. Paragraphs 14 and 15 in my submission, the slightly different approach he's talking about is respecting the content of the directive. And the point to note about it, though, as I say, if I may, I'll come back because I need to lay the groundwork, so to speak, for Del Cerro Alonso by showing you three other authorities first. But in paragraph 15, he refers to the three cases where it was argued that the whole of the public sector should be excluded. He does the same in paragraph 9 at the beginning of this section of his analysis. And our submission is that actually what he describes as a slightly different approach is just to treat the facts of Del Cerro Alonso as being another attempt to exclude the whole of the public sector from the coverage of the directive, which was defeated 3 times already and stood to be defeated again in this case.
Yes.
My lords and my lady, may I come to the authorities that in our respectful submission lead up to Del Cerro Alonso and then come back to Del Cerro Alonso itself. The three authorities are Vassallo, Moroso and Adelena.
So these are the ones referred to in paragraph 15 then?
They are indeed.
Yeah, thank you.
The sequence of them is that the Advocate General's opinion in Vassallo and Moroso was given first, and it was given jointly. It was an Advocate General's opinion in the two cases because they actually involved different workers at the same hospital. Then the judgment was given in the case of Adenela, and then the judgment was given in Vassallo and Moroso. I say that by way of an apology for the paper chase I'm about to send the court on. But may I begin with the Advocate General's opinion in Vassallo, which is in Bundle 4, tab 66. May I just tell the courts in a sentence what Vassallo and Moroso were about?
So we're looking at Moroso.
In the European cases reports, it's under the heading Moroso. In fact, it's the Advocate General's opinion on both cases.
I see.
And one sees that at page 7215.
Right.
Paragraph 2. These references were made in connection with disputes between Mr. Moroso and Mr. Sardino and also Mr. Vassallo.
Yes.
They were kitchen staff.
Yes, I see.
In a particular hospital in Italy, in Genoa, I think, and they were relying, or sought to rely, upon a right to convert successive fixed-term contracts into a permanent contract. The Italian government said that they couldn't do so because there was an overriding principle of Italian constitutional law that you could only get a permanent contract in the public service, up to and including kitchen porters, if you had taken part in an open competition for it. So what Italian law did instead was provide for a financial remedy if you had too many successive fixed-term contracts, rather than a right to convert it to a permanent remedy, to a permanent contract. And the European Court of Justice held that that was probably consistent with Clause 5 of the Fixed Term Workers Directive. But the relevance for present purposes of the Advocate General's opinion in Vassallo is at page 7222.
And it is the same Advocate General as in
As in Del Cerro.
Alonso.
He says, 25, preliminary remarks. Let me begin by dismissing the argument put forward by the Italian government in the Vassallo case that the directive applies solely to relationships between workers and private sector employers. To support this argument, it refers to the origin of the directive, which lies in an agreement between organisations representing private sector workers. That point is disputed between the parties. There is no point in considering the identity of the organisations which signed that agreement. Suffice it to say that the measure to be interpreted has the legal nature of a directive adopted by the Council. Then he sets out the scope which is set out in Clause 2. And 5 lines from the bottom of 26, it does not appear, therefore, that the directive intended that fixed-term employment contracts or relationships with public authorities should be excluded from its scope. So the first attempt to keep the public sector out of the fixed-term workers directive in this case was because of the parties who had negotiated the framework agreement. That was given short shrift in paragraph 26 by the Advocate General, and as we will see, it's also given short shrift by the court. But may I invite the court, if it's not too inconvenient, to keep that open, but to go to the next judgment in time, which is Adenela, which is at tab 40 in volume 3. This case, the Advocate General was Advocate General Cockott on Cs from 6062, but I don't think there's anything in the Advocate General's opinion that I seek to draw to the Court's attention. In the judgment, which begins at page 6093, at page 6118, the Court deals with a preliminary remarks before it goes on to deal with the questions in that appeal. And can I just list for the Court what the questions were in the appeal? None of them are directly relevant to the scope of Clause 2.1. Question 2, which starts at 6119, was the question whether it's enough to establish objective justification that the law of the member states allows the discrimination. The court said, of course not. Paragraph 69 to 73. The second question in the appeal, which was question 3, begins at paragraph 76, asks whether a member state can get around the limitations on successive fixed-term contracts simply by ensuring that there's a gap of 21 days between those contracts. And again, the answer is, I paraphrase, of course not. Paragraphs 82 to 83 of the judgment. And the third question was, which was question 4, was it permissible to have a blanket prohibition in Italian law, it was Greek law in that case, that fixed-term contracts in the public sector could never be converted into permanent contracts? And in that case, unlike Moroso and Vassallo, the court says that it was not permissible to do that because there was no other remedy. But that issue was considered not in the context of Clause 2, but in the context of Clause 5, the adequacy of remedies. That's paragraphs 162, paragraphs 90, 98 of the judgment and 102. So, I digress only to make the submission that actually the issues the court was actually deciding didn't go to the construction of Clause 2, but they do say something about it back at page 6118 in their preliminary remarks. With a view to giving a With a view to giving a helpful answer to the questions submitted, it should be made clear at the outset that the directive and the framework agreement can apply also to fixed-term employment contracts and relationships concluded with the public authorities and other public sector bodies. The provisions of those two instruments contain nothing to permit the inference that their scope is limited to fixed-term contracts concluded by workers and employers in the public sector alone. On the contrary, it's apparent from the very wording of Clause 2.1, which is then set out, that it encompasses all workers without drawing a distinction according to whether their employer is in the public or the private sector. So although the court doesn't there set out what arguments it might have heard as to why the private sector only should be covered by this directive, in my respectful submission, the explanation for it, given in particular that the Advocate General's opinion in Vassallo and Moroso had come out, is that the court is reiterating that there's not a quick and easy answer to why the public sector shouldn't be covered by the part-time workers directive, which is that because the negotiating parties didn't represent the public sector, so it didn't cover them. If I may move next back to the Moroso judgment that I hope we all still have open at tab 66 in the bundle 4.
Yes.
The issue, as I've already submitted, in fact, before the court, was about adequacy of remedy under Clause 5, whether it was enough that in the public sector you had only a financial remedy, whereas in the private sector they could make an order that you became a permanent employee. But the relevance for present purposes is paragraphs 39 and 40 of the judgment, page 7245. Having dealt with issues of admissibility, the court moves to substance. By its question, the National Court asks essentially whether the framework agreement, perhaps I won't read it, but it's about whether a bar on conversion into indefinite contracts is permissible. With a view to giving an answer to the question submitted, it should be made clear at the outset that contrary to the submissions of the Italian government at the hearing, those were the submissions referred to by the Advocate General, the directive can apply also to fixed-term employment contracts and relationships concluded with the public authorities, and reference is made to Adenela, and then very similar language to Adenela is used. The provisions of those two instruments contain nothing to permit the inference that their scope is limited to fixed-term contracts concluded by workers with employers in the public sector alone. On the contrary...
Private sector alone.
I beg your pardon, my lord?
No. It's private sector.
I do apologise. Yes, in the private sector alone. On the contrary, and then it's, I think the same wording is used as in Adenela. And just whilst we're on that page, paragraph 48 on the facing page shows that on the issue of substance before the court concluded that Clause 5 doesn't preclude a financial remedy only for misuse of successive fixed-term contracts in the public sector, even though there is a more substantive remedy in the public sector. And just for completeness' sake, if I can refer the court to the Vassallo judgment, which is at tab 85 in the same...
Did you get anything out of that further?
No, it just says the same. So can I just give you the paragraph numbers? It's 32 and 33.
So we're for tab 85.
Tab 85,
Yeah.
paragraphs 32 and 33 of the court's judgment, and indeed reference is made in Vassallo both to Adenela and to Moroso.
Yeah.
So there was a line of argument dealt with in three authorities of the court in which it was being suggested that a priori the part-time workers, or in that case the fixed-time workers directive, didn't apply to the public sector at all. Now I come, if I may, to Del Cerro Alonso itself.
And we're back to, yes, I mean, you're taking some more thorough look through, I think, now, are you?
I am, yes, indeed. I'm trying not to skirt the bits I skirted first time through.
Yes.
And Del Cerro Alonso is in volume 3, tab 51. And I invite the court to pick it up, page 147 of the law report.
Yeah.
Yes, it's Ms. Del Cerro Alonso, paragraph 2, is an employee of a public hospital in the Basque Country. She claimed allowances. What it was about were long service allowances for earlier periods. She didn't qualify for them because during those earlier periods she had been a fixed-term worker rather than a permanent worker. The question that was referred to the court, paragraph 5, in fact, has nothing to do with what we are currently interested in. The questions were, first, whether the coverage of the fixed-term work directive extended to financial matters, or whether it was just working conditions in the narrow sense. The court, of course, said, yes, it does cover financial matters. Funnily enough, however, the Advocate General thought it didn't, but the court found that it did. And secondly, is the very fact that domestic legislation provides for the discrimination objective justification? And consistently with the other authorities I've mentioned, the answer is no, it doesn't. The mere fact that domestic law says it's okay doesn't solve all of the questions. So this was not a case in which, on the order for reference, the question with which this court is currently engaged arose. The reason it was considered, of course, is because, as an intervener, the Kingdom of Spain revived, we say, the point that had already been dealt with in the 3 earlier cases. One sees that from paragraph 6 of the Advocate General's opinion. The referring court is in no doubt that regulated staff fall within the category of workers covered by the directive, and it therefore refrains from raising that question. But not all the interveners share those certainties. It's true in particular of the Kingdom of Spain, which takes the view that the directive is not applicable to the main proceedings, and so argues that the reference is inadmissible. And so the paragraph 7, the Advocate General raises the question as to whether a member of the regulated staff with public law status can be covered by the directive. And then he begins to answer the question by going first, in our submission this is significant, by going first to referring to the 3 authorities I've just taken you to, Adenela, Moroso and Vassallo, saying it's clear from those decisions that the provision of the framework agreement can, I stress melodramatically the word can, but can apply to fixed-term employment contracts and relationships concluded with the public authorities and other public sector bodies. And then goes on to set out the reasoning that one saw in his own opinion in Vassallo. And then he comes on to deal with the question in the present case and says that the National Court invokes the broad definition of workers in the equal treatment legislation. The Commission, however, disputed the relevance of analogy or use of the meaning in the Equal Treatment Directive in the present case. And I've already made my submissions as to why that's a different autonomous test. Then there's reference to no single definition of worker. And then it said, established in relation to equal treatment, the concept is an independent concept in community law and must be broadly interpreted. Therefore, possible that officials may be regarded as constituting a particular category of worker. But then he gives an example where they're not everybody is covered. It's apparent that in the Acquired Rights Directive, in which the directive is intended to achieve only partial harmonisation, reference must be made to the definition adopted by the national labour legislation. Consequently, if under that legislation a public law employee is not subject to labour law, he can't be considered to be a worker within the meaning of community law. And reference is made to the Dan Moles and Colino cases. Just pausing there, of course, under the Transfer of Undertakings Regulations 2006 in this country, only employees, strictly so called, are protected by the rights inherited from the Acquired Rights Directive. He then goes on to look now at paragraph 12 at the position in relation to the fixed term directive. Of course, I read 12 and 13 to you a few minutes ago, so I won't do so again, but I hope that I've made the submission that he treats as different the part-time workers and fixed-term workers directives on the one hand and the working time directive on the other. And then at 14, he says this: in this case, I propose to adopt a slightly different approach. In principle, it's right to respect the wording of the framework agreement, which leaves to national law the responsibility for defining the category of workers subject to the agreement. In this instance, it's apparent from the file that the claimant not being subject to labour law does not enjoy, under national law concerned, the status of a worker. It will be for the national court to satisfy itself that that is the case. The assessment cannot be carried out in isolation because the framework agreement is intended to prevent abuses. And it may be inferred from that the member state must define and interpret the concept of workers in such a way as to comply both with the objectives pursued by the directive and with general principles of community law, and in particular the fundamental principle of equal treatment. And that conditional renvoi, he says, is the process which is most faithful to the letter and the spirit of the legislation, which means that the member state cannot merely rely on the formal or special nature of the rules applicable to certain employment relationships in order to exclude the latter. If that were the case, there would be grounds for concern that the framework agreement could be rendered completely redundant. If that were the case, it would be open to any member state to make the contract staff of public authorities subject to special rules in order to call into question the decision in the three earlier authorities. Consequently, the exclusion of public servants from the scope of the directive cannot be accepted unless it's demonstrated that the nature of the employment relationship between them and the administration is substantially different from that between employees falling, according to national law, within the category of workers and the employers. The file appears to show that the Spanish Supreme Court has had occasion to rule on the content of the special relationship between a civil servant and their administration. However, it's for the national court to assess to what extent that assessment is consistent with the conditions laid down by community law. Now, in our submission, what's significant about that passage is that he doesn't close the door to the possibility that it might be all right under Spanish law to exclude the whole of the public service from the scope of the directive. Rather, he says that it could be possible if there was a substantial difference between the public sector, public servants and other workers. What he doesn't say is that the spirit and intendment of the directive requires that everybody is covered.
It's quite a sophisticated way of doing it, though, isn't it? I mean, it's looking very precisely at the content of the relationship, doesn't it? I mean, it's not, you can't just make a sort of sweeping generalisation. I think that point is fairly clear. You can't just say because they're public sector and because of the way the thing was negotiated, they're outside the scope of it. But there may be something in national law which has a particular content which would justify it.
So there may be some categories of public servants who could legitimately be excluded without harming the spirit and purpose of the legislation. But what it doesn't do is say outright there is an autonomous meaning of worker that must be used for the part-time workers, the fixed-term workers directive, and which covers everybody.
And it's something that renders that relationship incomparable with. Yes, I mean, that's what it comes to, really, that there's something in the national law which justifies a distinction drawn between one category and another.
Yes, a substantial difference. Of course, it's a rather inchoate word, substantial. It's not, if I may respectfully say, it's not entirely clear what's substantial and what's formal, but he is plainly recognising that there are some exclusions that can be permissible by reference to the domestic law. And the point in our submissions, it's by reference to the domestic law that the distinction is permissible.
Yes.
May I move on to the judgment of the court and picking it up, page 157. Preliminary observation. So since the question of the scope is not directly an issue, it's dealt with as a preliminary observation. And at 25, they move, in my submission, it's significant, the court goes straight to the three authorities I've taken to. In that regard is whether a worker such as the claimant comes within the scope of the directive. The Court of Justice has already ruled that it's apparent from both the wording of the directive and of the framework agreement, as well as from their background and purpose, that the provisions laid down can apply also to the fixed-term employment contracts and relationships concluded with the public authorities and other public sector bodies. It must be added that it's clear from Clause 1 the objective is to prevent abuses and to ensure the application of the principle of non-discrimination as regards fixed-term work. Having regard to the importance of the principle of equal treatment and non-discrimination, which is one of the general principles of community law, the provisions set out in that regard by the directive for the purposes of ensuring that fixed-term workers enjoy the same benefits as those enjoyed by comparable permanent workers, except where a difference in treatment is justified by objective grounds, must be deemed to be of general application, since they're rules of community social law of particular importance from which each employee should benefit as a minimum protective requirement. Accordingly, the directive and the framework agreement are applicable to all workers providing remunerated services in the context of a fixed-term employment relationship linking them to their employer. The mere fact that a post may be classified as regulated under national law and has certain characteristics typical of the civil service in the member state in question is irrelevant in that regard. Otherwise, in reserving to member states the ability to remove at will certain categories of persons from the protection offered by the directive, the effectiveness of the community instruments would be in jeopardy, as would their uniform application in the member states. See by analogy Jaeger. And then it goes on to say, since it's agreed that she worked for 12 years, the claimant comes within the scope of the directive and of the framework agreement. Now, our respect for submission in relation to these passages is this, that what the court was trying to spell out here was that two things. One, you cannot simply say, public sector, this doesn't apply to the public sector. That's why there's a reference to Moroso and the other two cases. Secondly, they were saying that you cannot rely upon a member state definition of worker which wholly runs counter to the content of the directive itself. What they are not doing is challenging the wording of the directive insofar as it allows member states some leeway in deciding who is and who isn't covered by the scope of the directive.
Is the critical phrase in paragraph 27 the phrase about 6 lines down beginning with except. Just certain treatment justified by objective grounds.
Yes, although I would go further than that, my lord, and say that the clue to understanding it is what the court thought it was thinking about at paragraph 29, which is the reference to removing at will certain categories of persons from the directive. What they're saying is a wholly irrational exclusion of certain persons is not permitted. Forgive me.
Just saying that the general principle in the directive is no discrimination apart from where justified by objective justification.
Oh, I see, yes. And I'm sorry, I'll just take the advice given to me by Miss Moore before I take the advice given to me by Mr. Allen. But Miss Moore makes the point to me that that paragraph 27 is really the words that my Lord drew reference to, a difference in treatment justified by objective grounds, is just a general reference to the standard formula that one sees in the directive. It's just defining what the directive does. And so it would be wrong to take from that. I see I've done Mr. Allen an injustice because he was making the same point, so I apologise if I was rude. But it's a reference indeed to the text of Clause 4, so one doesn't really draw much help from that. I will come... I see the time, my lords, and maybe it will have to be after the short adjournment, but I will come briefly to the INPS case, because we say in one sentence that case is not relevant.
Yes, I noticed that.
To our case. But if I can just pause, therefore, at the end of this review of the European authorities, our primary submission is that in light of those authorities, it is at clear that there is no autonomous, comprehensive definition of worker for the purposes of the Part-Time Workers Directive. That it is act clear that whilst there may be difficulties at the margins in considering whether a particular exclusion exceeds or does not respect the content of the directive, an exclusion which is limited to a relatively small group of people does not exceed the member state's discretion. Of course, I'll have to come back this afternoon to deal with the status of judges in domestic law. But if those two propositions are right, we respectfully invite the court not to refer but to find for us if the court is against us on that. We say that at the very least, given that the facts in Del Cerro Alonso are so radically different from the facts in the present case, and given also that the issue of the scope of Regulation 2 was not even a live issue in the reference in Del Cerro Alonso, it cannot be said on the basis of Del Cerro Alonso that the point is act clear against us.
Do you say that in the light of what the court said in Del Cerro Alonso, that the remarks made by the Advocate General in Whipple about the very broad nature of the discretion and so on, there's no reference to any of that here. No. Does that still survive, do you say?
Yes, we respectfully say that it does. That it's wholly compatible with the Advocate General because she does qualify what she says by referring to respecting the content of the directive. And we say that the explanation for Del Cerro and the three cases which preceded is that there was a rather audacious attempt by member states to define worker and suggest that the directive applied only to the private sector in a way which was would wholly have undermined the purpose and content of the directive.
Well, would that be a convenient point?
Indeed it would, my lord.
Mr. Governor, to break off, and we look forward to seeing you again at 2 o'clock.